Okay, it's the top of the hour, and we're going to get started. We have a great presentation on TAP today. I'm going to do a brief introduction, and then I'm going to turn it over to our presenters, Dale Yeager, Andy Demidont, and Jack Stollsteimer. We thank you for taking the time out of your day to join us, and we're going to begin right now. Good afternoon. Welcome to today's webinar, 5 high liability issues for public schools. A 1-hour interactive webinar which will focus on 5 key issues related to the safety and security problems in elementary, middle, and high schools. During today's webinar, our presenters will cover 1, the lack of accurate understanding of safety issues, 2, reaction, not prediction, 3, poor management of schools, 4, lack of effective plans to combat truancy and lateness, and 5, poor emergency management. Our presenters for today's webinar are listed on the screen. Dale Yeager is the President and CEO of Seraph, a consulting and training firm. Seraph offers corporations, schools, colleges, hospitals, government agencies, municipalities, law firms, and individuals a vast array of programs to solve problems. In 2000, Congress tasked Dale and his expert team to produce a State of School Safety in America report. To date, Seraph has provided 3 of these reports. Andy Demidont is retired from the public education system after 35 years of experience. During his tenure in public education, Andy held various positions such as assistant principal, high school principal, and superintendent. He also taught graduate education courses for Mansfield University. Andy has been nominated to serve on a statewide task force on restructuring the education system in Pennsylvania. He also is the recipient of numerous state and national recognition awards. Jack Stollsteimer was appointed by Governor Ed Rendell to supervise an agency staff empowered by law to monitor the school district's reporting of incidents of violence to the state, to offer assistance to victims of school violence, and to recommend remedial legislation and school districts' administrative reforms to promote safe schools. Jack has also served as Assistant United States Attorney for the Eastern District of Pennsylvania and the Assistant District Attorney in Delaware County. I'm now going to turn it over to Dale and his team, who are going to lead us in the presentation today. Dale, your team, it's all yours.
Good afternoon, everyone. What I wanted to do was kind of give you an overview first of what my portion of this, which is to talk about those critical issues that Matt had explained in the introduction, and then I'm going to open it up for questions. There are always a lot of questions, and Andy and Jack will be answering questions based on what the subject matter is. We did have some questions that came in yesterday and the day before, so we will address those questions also. But let's get started talking about school safety in a radically different way than you're probably used to. My PowerPoint is not working here.
Sorry, Dale, just click on the tab that has SCH Safe TASA. There you go.
Okay, forgive me. So, school safety, 5 high liability issues for public schools. And this presentation is going to be relevant for both school boards and school districts, as well as attorneys who have litigation against school districts or schools in general. So let's start first by talking about accurate information. There's a lot of myth out there, and one of the things that we want to do is talk about facts, because if you don't start with good, accurate information, you're going to make bad decisions. And first of all, we get all of our information from reliable sources, in this case the Juvenile Justice Bulletin from Office of Juvenile Justice for the U.S. Justice Department. They really have, as far as we can see after 20 years, the best and most accurate information out there available. So here's the current data. 2.7 million crimes are committed at schools every year in America. Of that 2.7 million, about 73% are suburban and rural schools. The first thing I want you to understand is this is not an urban problem. This is an everybody problem. One of the things that we find in working with our 26,000 school clients over the last 20 years is that suburban schools and rural schools do not put the same emphasis on this issue, and in many cases because they've never had a proper assessment done of their management and their security issues, they have only a surface view of the problem. And that's not a criticism, it's just a fact. I mean, we have a pretty good sampling over 18 states, and we see this pretty consistently. One of the problems, again, is people thinking that this is an urban problem, but statistically, when you look at overall crimes in schools, it is a suburban and rural problem. Students ages 12 through 18 were more likely to be victims of non-fatal violent crimes such as rape, sexual assault, robbery, and aggravated assault. Total crimes committed in schools of this age group, 253,000, and again, 60% of that number are suburban and rural schools. Again, not an urban problem, it's a problem across the board. Teachers are victims of over 400,000 violent crimes each year. Now, I don't like raw data, and I know some of you are saying, well, there's more than just raw data, so let's break that down. So of the 400,000 teachers, there are three groups of people that assault teachers. Now, teachers under the Justice Department regulations are also going to include administrators. So it's teachers, administrators, school counselors, that group of people. Of that 400,000, number one is students. Number two, though, is parents and guardians. In fact, they're only 5% behind the student number. And then right behind that are other staff members. And so the first thing I want all of you to do is stop thinking about school safety as a bully issue or school shooter issue. Schools have adults and children, and both can behave badly. And so I want you to think about it holistically and think about school safety as a problem that encompasses many areas of the school, not just the classroom. Next. Now, there was a question here, and I will save that to the end. I want to go through this first, and then I will take William's question and answer that at the end. So what are the types of school violence? Again, I want you to think holistically and not focus just on one area. Student to student, student to teacher, teacher to student, teacher to staff, staff to student, vendor to student, visitors to student, visitor to teacher. I want you to look at F, vendor to student. 32% of all crimes committed against students and in schools in general, according to the Justice Department, are by vendors. Coke man, the milk lady, the guy who comes and sells insurance to teachers. Anyone who is not staff or students in a school is a stranger from a security perspective, and they must be monitored. Now, many schools have spent an extraordinary amount of money, and in our opinion, too much money on school security cameras. And the problem with a camera is that a camera, and there is no camera that I know of, that has cognitive ability or peripheral vision. Only human beings have that. And when people rely too much on cameras, there is disaster coming, and it increases liability issues dramatically. And so vendors can't just get a pass, sign in at the office, which is the standard policy. They've got to be monitored when they're in the building, as well as parents, as well as school board members, as well as any visitor who comes into the building. They must be monitored. And there are many ways that we've developed over the years from a management perspective to do that, which does not disrupt the normal management of the school. But the bottom line is that there is, in this list, a vast array of problems that are occurring every single day in every type of school. And so again, we want you to think of this in the larger setting. Number one, lack of accurate understanding of safety issues. You cannot, as an administrator and as attorneys who are defending their clients in lawsuits, you cannot make decisions based on a lack of understanding. And one of the things we talk about in our training many times is the issue of juggalos and straight edge. In the state of Pennsylvania, in New Jersey, in all states in the United States, every single high school has juggalos or straight edge. These are two gangs. The federal government classified them as gangs many years ago. In fact, if you have juggalos or straight edge, you as a school qualify, and so does your community, for gang interdiction money. When we mention these two, most people roll their eyes and say, what's a juggalo and what's a straight edge? These are negative youth behavior movements that are gangs that have actually killed and injured police officers and students. They're very violent. They attract regular kids, both males and females. I don't have time to go into it here, but there's much information that you can read about juggalos and straight edge. So when we say that a school district has a gang problem, people will say, well, that can't be. We don't have Bloods or Crips. We have to, again, think broadly. We have to start thinking more holistically about this issue and understand that gangs are not just the ones that you see in the movies or on TV. There are other things going on that can cause violence and liability issues within a school system and certainly affect the safety of students. Number two, reaction, not prediction. We find that school boards primarily will react to problems rather than predict and prevent them. When we put this program together, when we put this company together, one of the things that I decided to do was hire only retired school superintendents and administrators who actually had run school systems. You can lie to a police officer, you can lie to a security person, you can lie to an attorney, but you can't lie to an administrator who's been there and done that. And so one of the things that we find is that educators need to teach educators school safety, and that a well-managed school is a safe school. You'll hear that a lot from us. We have found, and after 20 years, we think we have a pretty good sampling from a scientific perspective, that most of these problems can be managed away. And the beauty of management is it costs no money. Management is the key to predicting and preventing the problem from happening in the first place. So reacting is never a good thing. That increases liability, and that is one of the reasons why students get injured, staff get injured, and that there are increased liabilities in some schools and some school districts. Number three, poor management of schools. Poor time management. The management of time has to do with the management of students during lunch, where there are a lot of problems in many schools in the cafeteria. Poor time management in students moving from one class to another. Time management becomes a critical issue in lowering liability and the reason why there are liability problems within schools. Non-data-based decisions. If you're going to base them on your feelings, or I think it's kind of like that, well, that's going to be a problem. And that's where we find a lot of liability, again, increasing dramatically because people are not collecting the accurate data. But that's another issue unto itself, because many administrators do not have the tools necessary to collect all of the data, because they can only collect what they know about or what they understand from an educator's perspective. That's where a proper security management audit comes into play. Unwillingness to depart from conventional thinking. People change. Society has changed. Since the mid-90s, as a criminal analyst who works on criminal cases and trains law enforcement, we have noticed dramatic changes in American family structure and in children and in the level of narcissism in people in general. You have to factor that in to your security management plan of action, and that sometimes is not done. School boards being asked to make decisions without essential data. Many times we find that school board members are not asking the right questions and getting the information that they need. And sometimes when attorneys are bringing a suit against the school district, one of the things that they fail to do is ask for this data, because many times they don't know what data they should be asking for from a state and federal level, from a management perspective. Poor use of technology to handle the mundane tasks. This is critically important. Technology is a good thing, but it's secondary to good management, and that technology can actually, again, manage your time better, and managed time actually reduces liability. Technology is good, but again, cameras cannot reach out and stop a crime. They can't think for themselves. They don't have peripheral vision. Alarm systems can only do what you program them to do, and a lot of money is being wasted where it doesn't need to be in school systems. Lack of effective, ongoing, interactive, community-wide communications. It amazes me how many school districts that do not have regular news conferences or send out regular news releases and deal with the press and the media on a consistent basis. And because of that, a lot of rumors get started which get out of control. Also, the internet is a powerful place. It's the wild, wild west. And if schools are not monitoring the internet, a lot of things are going on in the internet being said about the district, or preemptive crimes are being planned on the internet that could have been picked up by the IT person and are not. Again, this is a lack of management of IT tools and technology, and then that communication ends up on the internet, is spread as a rumor throughout the community and causes even more problems, and in many cases can actually cause a crime to be committed. And we've seen many of these things on the news with girls and boys saying things about each other on the internet. No one's monitoring what's going on, and what happens is it gets out of control and violence occurs. Number 4, lack of effective plans to combat truancy and lateness. Truancy is the root of all school safety problems. I'm going to say that again. Truancy is the root of all school safety problems. Truancy, which includes lateness, is really code for dysfunctional families. Dysfunctional families produce two things. They produce dysfunctional children who are either the bully or the bullied. They produce children who end up in negative behavior cliques and gangs. They end up being they end up producing children who have a lot of serious issues that really can create liability problems in a school environment. And so the first thing that has to be dealt with on a school safety level is dealing with truancy. And that truancy plan is only as effective as what it is being executed. And again, for school administrators that are listening, or attorneys, or school boards, this is something you need to focus most of your attention on. For those of you who are attorneys who are bringing suit against school districts, this is, again, a place where you need to focus your attention. How is that being executed, and how effective is it? And by federal law, it's required to be managed properly, and there are deadlines for it coming up under NCLB, or No Child Left Behind. Number 5, poor emergency management. Don't ask untrained people to do what trained people do. It amazes me when I hear people say, we're going to test our emergency plan. You do not test an emergency plan. You test the people using the plan. Because the plan itself is only words on paper. That's all it is. And unless you take the people and actually test them using the plan and seeing what their weaknesses are, you don't know how they're going to act in that situation. We do training for the Pennsylvania Emergency Management Agency, along with other emergency management agencies throughout the country, as well as schools. And one of the things we find is that many people have never been in a serious emergency. They do not have the psychological skill to control panic. One of the things we say is fear is biological, panic is a choice. Panic is a narcissistic reaction by people who are not properly trained to focus and stay in control of themselves. I worked on the Columbine murders. One of the things that we found out, which was a dirty little number that nobody wants to talk about, is that 38% of the teachers at Columbine abandoned their students and ran out of the building. When we did our report for Congress several years ago after 9/11, we surveyed administrators in southern Connecticut, northern New Jersey, and the suburbs of New York City, out in the oranges. We found that, on average, 70% of adult staff left that day without permission. So one of the things that we teach is that the emergency plan in a school you have to be able to implement it with only 40% of your adult staff present. Some will run away, some will be dead, some will be injured, some will be on vacation. There's a kind of a fallacy among administrators sometimes that everybody's going to be present, and that's just not true. And most emergencies end poorly or are poorly managed because of a lack of training. Again, you cannot ask untrained people to do what trained people do. That is just bad policy. So, in conclusion, liability, in our experience as researchers for Congress and also our work for 20 years, really focuses and has always focused on management. You can pretty much prevent and predict anything, and I mean anything, in a school environment with proper management. And failure of management is really the key in many of these situations. And as we always say, and what our motto is, educators teaching educators school safety, but also a well-managed school is a safe school. So what I'm going to do now is I'm going to answer William's question, then I'm going to ask you to submit your questions, and I'm going to have Andy and Jack answer them for you. But William asked, 12 to 18-year-olds are more likely than whom to be victims? Well, of adults, so those over 18, and also children who are actually under the adolescent age, which is 11 and under. So that hopefully that answers William's question. So let us know your questions that you have now, and we'll have Andy and Jack come in and answer them for you.
Andy, Dale, and Jack, I have a couple questions that have been submitted to me through the chat feature. I would encourage all the attendees to use the chat feature, which is located on the right-hand side, to submit your questions to us and to the presenters. Guys, is there a management audit template that our audience can reference or use locally? Like, do municipalities have a management audit template, or school boards? Or is it something that is really unique to each individual school district?
Well, before Andy answers, let me say that there are audit templates out there which Andy can talk about, but they're very poorly designed. They're very focused on equipment and physical structure. A school has to be looked at from a management perspective, and it has to have an educator's eye. And so that's using those templates is not going to get the data that you need or the information you need. That's going to cause a problem. Go ahead, Andy.
Basically, what I was going to say is that we have developed our own template for management practices that we look at, and it begins from the very essence of how schools are supposed to run, which is board policy, all the way down to handbooks, and then all the way down through how those policies and procedures are disseminated, communicated, verified that they're being practiced, and our template also does a very thorough examination of what's written, what's practiced, and is it actually being executed in the manner that it was intended to be executed. So when we look at that template that we've developed, we look at it from a very comprehensive perspective, all the way through the written documents. How was it formulated? How is it practiced? It is absolutely mind-boggling the number of times that you will find policies and procedures that have been put in place by school boards that basically no one is aware of. And it goes back to one of the things that Dale had mentioned earlier in his part of the presentation, that you have this sense that if I have it written, I'm finished. That's all I need to do. And that's obviously going to be a problem from a litigation standpoint if it's written and it's not practiced. Many schools, I'll give you an example, have policies and procedures that ask teachers to do quick sweeps of their buildings during a bomb scare. Well, you know, that of itself has a potential for some serious problems without, again, making sure, as Dale alluded to earlier, that those people are properly trained to do that.
Jack, would you like to give a thought about the accurate assessment and auditing of schools?
Well, you know, from my perspective, just as Andy said, from a sort of a legal perspective, if you don't do it correctly, if there is templates out there, or if you have, the school district has attempted to follow a plan and they're not following it, that's when it's really going to present the problem. If the school district has a plan, a safety plan, or anything of that nature, and even the law, if they're found to be not following state and federal law, for example, I think you're going to find that that becomes a basis for liability.
And let me say this, Matt. One of the things that I always find interesting, and all of us talk about this as a problem, is that schools across America have designed school safety plans without ever doing a proper management audit to find out what's working and what is not, and what the issues are. It's putting the cart before the horse. First you have to assess, then you have to base your policies on that assessment. It's like going to the doctor, getting treatment before you get tested for what the problem is. And this is a critical liability issue. When you have a safety plan that has been done, and there hasn't been an annual audit done because everything changes each school year. There's not an audit being done every year. I mean, that is opening up major liability for that school district because they are using old data to design their new year's plan. And I would strongly urge any of you listening, do not, and I repeat, do not copy somebody else's plan or someone else's audit and then use that for your template. And I'm going to tell you why, because any good attorney is going to use plagiarism software to find out where you copied it from, and they're going to say, what does Roanoke, Virginia's safety plan have to do with yours in Pennsylvania or New Jersey or Massachusetts? And again, these are things that have to be custom built. They have to be customized because every school is different, every district is different. So that's what I would say in conclusion to that, Matt.
We have a question from William who asked, what options does a school have when a known sexual predator, student on student, other than continuous adult supervision? So how can a school deal with a known sexual predator who's known to have committed student-on-student sexual acts, I guess, other than continuously monitoring that individual with adult supervision?
Jack, do you want to take that first before Andy?
Well, first of all, the question is whether or not the act was committed on the school. If he's a sexual predator because he committed a sexual criminal act at a school facility, he can be expelled and can be excluded from the school setting permanently. Schools can also, and they do this in Pennsylvania frequently, create alternative education programs or contract with alternative education providers. And it's relatively simple under state laws, at least in Pennsylvania, to remove a kid from the regular school setting and put him in an alternative ed setting. And the argument there is that's better both for the potential victims or the victim and for the offender, because clearly that child who has that predilection needs to be given behavioral supports above and beyond what he can probably find in most regular school settings anyway. So first, you got to determine whether or not the act was committed in the school. If it was committed in the school, they're going to have to follow their code of conduct, and they should remove that kid by a formal expulsion and put him elsewhere. Second, if it wasn't committed in the school, but he is a student there, I would seriously investigate any alternative placements you can make for that child, because the school, I think, has a duty to keep the other students in the school safe.
Andy?
There's really nothing else I would add to it. I think Jack just covered that pretty well, especially with that last part. You know, you can take an affirmative act when you have a sound basis for jeopardy to the larger student body, because almost every state school code or policy or law has a provision in it that requires the school to protect the health, welfare, and moral well-being of all of its students above all else. And certainly if you have a predator, a known predator in your school,
that's right.
I think you'd probably be on very firm ground making that alternative placement. And if you were a special needs student, the basis would include just a step of a simple behavior task analysis for that particular student to rule out whether a behavioral manifestation, to rule out whether that student his behavior was a portion or attributed to his or her exceptionality, which I would find very interesting reading if that were an argument that was made.
Matt, I would also add that the Justice Department announced last November that they were sending out investigation teams to school districts throughout the United States to investigate violation of civil rights of students, and particularly sexual assault. And Jack, correct me if I'm wrong, but if you are an adult and you do not report such a crime, that's obstruction of justice. Is that correct?
Well, the facts are very important in that, and I wouldn't want to sort of speculate.
But if you deliberately hide the crime,
a charge could be made, especially under state law, that if a school administrator who had a duty to report the incident under the law failed to report it, then it could be a criminal act.
Okay.
And as you know, Dale, and as Andy knows, and people in Pennsylvania should pay attention to this, and it's flips right into what you were talking about, Dale. There's a test case right now in the Allentown School District in Pennsylvania where school officials deliberately covered up and failed to report a violent sexual predator. A 12-year-old boy who committed violent sexual acts in school building against a couple of younger children. That district is being sued in the federal court here in Philadelphia. And the U.S. Department of Justice's Civil Rights Division just last summer entered into that suit, became a party to it, because under Title IX and also in the Civil Rights Act, in Section 1983, they want to monitor the suit but also be directly involved because of exactly what Dale was talking about. These things are happening across the country where kids are being sexually assaulted in schools, and if school officials are not reporting that, either to the police or to the departments of education as they're required to under every state law, that's going to become a basis for liability. So the feds are starting to become aware of this lack of reporting, which is a larger issue we can talk about as well.
The other aspect of that is, Dale, the other aspect of that is that, and it has been on the books for years, the Child Protective Services Act requires that duty to inform, not to evaluate, not to judge, that there is an inherent duty on the part of school people, whether it's an administrator, a school nurse, a classroom teacher, to report suspected acts of violence of any type, really, under that.
And Andy, every state has a form of that in one way or another. So.
And in Pennsylvania, that law has been tightened for that reason because people are getting concerned that people are not reporting these things.
Well, the Justice Department, it's interesting because the Justice Department, when they did their research back in the late 90s and early 2000s, they found that the bulk of sexual assault was happening in special education areas of schools, and that was where the majority of them were happening. And this is a whole nother issue that is not really very well addressed, and it's now getting addressed. And so schools have to they have to deal with that because there are children, just so everybody understands who's listening, there are children who have mental issues, they have mental illnesses, or they have physical disabilities, and also in special education there are children who have personality disorders. They're not mentally ill, they're not physically disabled, they have a personality disorder. And the problem is when you mix the three groups together, it's a very volatile situation. And while inclusion has been a very positive thing, and I say that as a brother of two siblings who are physically disabled, I will say that it also was not really thought out very well when it was implemented in schools. And now children and adolescents are paying the price for it. And there's a management issue, again, in special needs classrooms that we see on a pretty constant level. So, Matt, I've got another one up here. Should I just read this question from Stephen?
Sure, go for it. Yeah,
okay.
Go for it.
How should a school handle a suggestion from a student that suicide is being considered? Should parents be notified? Should police be notified? Jack?
Yes.
Yeah.
You have to take that as seriously as possible. Bring this child in. The administrator should get that child into their office. They should alert that child's parents. They should alert the authorities. They should get whatever behavioral supports. In today's environment, you simply cannot allow any piece of knowledge like that becomes relevant or becomes apparent to go unaddressed. And so if it's any suggestion at all that a child is considering something like that, or is considering the opposite, where they're considering damaging, causing serious harm to other school students, that has to be addressed right away with full force. That's my advice.
And that would be mine as well, because, again, that duty to report or duty to inform, not to evaluate, not to determine, but the duty to report is very, very clear and has been supported in almost every jurisdiction at every level throughout this country.
And one of the things in Andy's career that before he came on board with us, he was being very proactive very early on in participating in coalitions in communities to provide that support and stop the disconnection that was very common and is still common on a county level and a local level, and he saw the need for connecting the school into social services and the court system in a more intimate way than is even being done today. So I've seen that in action. But any other questions from anybody?
Dale, I have two.
Yes.
The first one is from Marvin, who asks, is a failure of protection of the student's safety ever characterized as a violation of civil rights?
Jack?
Well, it can be. The cases I've seen under the 1983 cases that have been brought primarily here in Philadelphia have not been successful so far. Most because I think the courts are very reluctant to find the school liable for things that they really can't totally control. So the unplanned acts of other students aren't really going to be seen to be fertile ground for recovery for a litigant. There are also cases where the state created danger, which is a very high hurdle for the litigant, for the plaintiff to get over as well. But there are going to be cases, and they're all fact-sensitive, and there are increasingly, here in Philadelphia, there's been increasingly more and more of these cases filed in federal courts. So far, the plaintiffs have not succeeded in any case I'm aware of here in this jurisdiction, in the Third Circuit. But I think you're going to see more and more of that over time, especially as the idea of what a state-created danger, if that standard gets changed over time by any of these decisions, I think you're going to see more of these cases.
Dale, we have a question from Robert, who asked, how much violence is committed by special ed students? What problem exists with handling these issues?
Well, again, the Justice Department, through Office of Juvenile Justice, have done studies over the last about 10 years, actually longer than that, probably about 15 years, showing increases in violent behavior, mostly sexual, in special education classrooms and special needs areas of schools. The statistics are, again, when you're collecting this kind of data, the Justice Department has a formula for figuring out what's not being reported. But when you look at the numbers on usdoj.gov, you will see that that's the tip of the iceberg, and it's a continuing problem that we see on the ground when we're working in schools. That there's a lot of assumption by school boards, in particular, that special education teachers have training in dealing with violence and aggression by special needs children. And I will tell you that that's just not the case, because we end up doing that training for them. Many of them don't know how to handle children who have Asperger's syndrome or other forms of autism, or have other conditions when an emergency occurs, which is a critical issue that's never addressed that we've ever seen in any emergency plan of any school, how those different needs are addressed. So in answer to the question, it's significant when it comes to sexual assault. As far as other violence, it's a roller coaster of statistics based on each individual school, and I've seen it very high in one school in a district, and then in the same district very low in another school of the same grade level, two middle schools. So there's not a lot of raw data that you can use for scientific purposes, but certainly for policy purposes there are. And litigation-wise, it's certainly an issue. But again, it comes back to another problem, which is how much do you know, and what is the detailed data that you have on your school system? Have you had a proper management audit done, or are you having somebody come in who doesn't understand education, looking at how high the bushes are and how many cameras you have, or have you either internally or from an outside agency really dug deep to see what the problems are and how well things are being managed? I mean, that's really the bottom line. So hopefully that helps.
On the discipline side, let me say that there's a lot of misconception about what can or can't be done to a special needs child in terms of discipline. And the bottom line is, even under federal law, all that is required. A child with special needs can face the same disciplinary sanctions by and large as any regular child. You just have to go through more steps. As long as whatever act that child committed, whatever violent or sexual act that child committed with special needs committed, as long as it was not a manifestation of his disability, which most of these things are not going to be, and you go through the procedural steps of bringing his IE, his team in, his behavioral support team in to go over what his IE plan is, and all of that stuff, you're going to be able to discipline that child and hold him accountable, and most importantly, oftentimes remove him from the regular school setting if that child with special needs who has these violent tendencies is going to continue to present a danger to the other kids in the school. So you want to make sure that you get through. I mean, in Philadelphia, it's amazing. Special needs kids oftentimes will taunt teachers saying, you can't discipline me, you can't get rid of me for acts that they commit in the school. And that lack of understanding that special needs kids can be held accountable for their actions as long as it's not a manifestation of a disability is something that even teachers and administrators didn't seem to know in Philadelphia. There's a lot of confusion about that.
And I would suggest that is a pattern throughout this country, that administrators who are charged with the responsibility for knowing what IDA regulations require and what special needs students require have a gross misunderstanding of what is acceptable behavior for special needs students within a school. They believe that definition makes it almost impossible in many instances to discipline a student who has a special education diagnosis. And nothing could be further from the truth. As a school person, as a school administrator, understanding the legal ramifications of what you can or cannot do with special needs students is an area that is, in this late day and age, still a huge gap in management training for schools. That understanding that to do a behavior manifestation analysis is the requirement that meets the test. If the student's exceptionality is at the root cause of his or her disciplinary behavior, there are certainly other alternatives, but you do not have to give carte blanche to that student. If the behavior manifestation determines that that student's behavior is not a part of his or her exceptionality, normal disciplinary procedures determine what outcomes will happen to that student. And if there's anything that needs to be really brought to bear, it's administrators understanding what they can or cannot do under the IDA regulations.
And I'd like to add something else, Matt, if I can.
Sure, go for it.
This is Dale Yeager, the criminal analyst, talking. One of the things that we tell administrators in these hearings is this: ask one question and demand an answer for this question. What part of this condition or behavioral assessment is cognitive? No one ever asks that question. And I'm going to tell you right now that most of the assessments of children are done by people who have a lot of theory about the human mind but cannot back it up with empirical data. And those of you who are attorneys who are representing these children, you need to understand that weakness. And also those of you who are administrators or school board members or attorneys for school districts need to understand that is the weak point for any litigation or any of these issues on discipline of special needs children is what part of their behavior that they just did was cognitive, that they were conscious of. Prove it. Because when you demand that, you will find that many of these assessments can't be defended scientifically by the Dilbert standard or any other standard, and that is a weak point on both sides of the legal issue. And that question has to be asked. It has to be asked.
Fastest growing group of classifications has become ADH. Okay? The problem for most administrators is they do not understand that there are really two tests for ADH. The standard test that is frequently used is a symptomatic one. And I bet if I gave that to most of the participants in this conference right now, most of you might have some or many of the classifications that are symptomatic indications of ADHD classification.
And so
clinical definition is a very, very, very small portion of the students who are out there with that particular category and description.
And I will reemphasize the fact that there's a lot of, for lack of a better term, a lot of pop psychology out there that has been disproven. And when we work as legal experts, I pull up the data that says, well, that theory of human behavior has been disproven, and then they're stuck. Well, how do we prove it in a court of law that this condition, this child has no cognitive function and didn't know what they were doing? I'm going to tell you right now, I deal with some pretty heavyweight in the criminal world. I deal with some pretty heavyweight adults and juveniles. One of my specialties is sexual assault by juveniles. And I will tell you that even schizophrenics who are mentally ill have an understanding of right and wrong and have cognitive function. And they are mentally ill. And so this idea that, well, I didn't know what I was doing is really a lot of nonsense, and it can't stand up to legal scrutiny. And the question is, are you as a school board going to be tough enough to get what you need to challenge that? And if you're the attorney representing that child, you better understand that that's a weak point if someone challenges that from a scientific perspective, because it will not stand up to court standards of expertise. We have been accepting for a long time a lot of theory that really has no basis in reality. And this idea of saying, well, people do not understand what they're doing, believe me, is a lot of nonsense. And it's a weak point on both sides of the liability issue. So anyway, there's a question here, Matt. Do you want me to read this from Stephen?
Sure, go for it.
Okay. Is there a state or federal law that requires yearly review of the school safety plan for the school? Does this require an outside review? How should it be done? By state law, there are, most of the time, what we have seen in most of the states we work in, both in the Midwest and the East Coast and the South, there are suggestions by DOE and by the state that be done. But Jack, do you know of any specific state law that require?
I know of no federal law, and in Pennsylvania there is no state law that requires a school to review their safety plan every year. But let me just say that, and if the situation I think is true in Pennsylvania, this is true in most of the states. Even the minimal legal requirements that there are to dealing with school safety are largely ignored by a lot of the school districts. For example, in Pennsylvania, it is a legal requirement that schools have a memorandum of understanding with their local police departments over how emergency situations will be handled, when police will be called to the school. All of those kind of issues are to be resolved through that memorandum of understanding. The state auditor general in Pennsylvania did a review of that about a year ago, actually 2 years ago now, and was stunned to find out that the overwhelming majority of Pennsylvania's 500 school districts don't have a memorandum of understanding with their local police forces, even though that law has been on the books since 1995. So there's very minimal legal requirements. There's even more minimal oversight from the Departments of Education. I would gather if that's true in Pennsylvania, it's probably true in most states. And this is something that's sort of a big problem and a big hole. And I would suggest, as Dale did earlier, that even if there is a requirement that there has to be a plan that is to be reviewed, the question is, well, what does a review really constitute? And I think, as Dale suggested earlier, it's not just appropriate to have a review of the plan every year where you sit around and you talk about, well, if something happens, this is what we should do. You actually have to put these plans into action. There's no better way to do it than to actually have a tabletop exercise with your local police forces, or an actual real school incident report where you go through and you fake an incident and you have everybody respond. We did that in Delaware County back in 1999 when I was in the DA's office, and it was fascinating to see how a plan, just like a war plan you always hear about, goes out as soon as the first, is thrown away as soon as the first shot is fired. Same is true of any school safety plans. You're only going to reveal the holes in the plan and the lack of professional development and training for the people who are supposed to play key roles in that plan if you actually try to physically put it into practice. So I'm not sure that's more of an answer than you expected, but legally there is no requirement that I'm aware of in the federal law. In Pennsylvania, it's certainly not true that there is a state requirement, but I would suggest to you that this is something that we need to address on the ground anyway.
But let me answer Stephen's part two of that question, which is, does this require an outside review? If you were sick, it's very hard for you, if you're seriously ill, to sit at home and diagnose yourself. That's kind of ridiculous, and ultimately you need a professional to do that. You also need objectivity. It's very hard to be objective if you're going to try to assess your own problem. So whatever you decide to do, in fact, under some of the federal funding for the stimulus, it actually says, and many schools are violating federal law, by the way, under the REMS grant, where it says you must partner with outside agencies and organizations, and some of them are just keeping the REMS grant money and doing it all in-house. And I'm going to tell anybody who's listening from a school district that has a REMS grant, the Justice Department and the Department of Ed in Washington are very aware of this. I've talked to them about this, and they are sending out auditors, and it's a tougher environment than it was back in the 90s. And so you need to ask yourself, well, how do we review these safety plans and find out if they're working or not? And, again, you don't have a lot of options there. Secondly, how should it be done is the third part of your question. Well, again, it has to be active. It can't be just a review of the policy. And that's what most school districts are doing, which opens them up to liability. Well, we took the plan, we looked at it, and we said, well, based on what we know, that seems to be working. Well, you're only seeing part of the story. Any administrator is only seeing part of the story. They don't have the whole picture. And so, again, logic dictates how this should be done. And logic says you're going to need an objective review of this, whoever you use, but you're going to need to have somebody outside of the entity to do that. So that would be our answer to your question, Stephen. Are there any others, Matt?
I have two more for you guys. Robert asked, do you advocate having police officers assigned to campuses?
Well, let me answer that, and then Andy can answer that. We're big fans of SROs, school resource officers, and SROs have been around for about 40, 45 years. They were first developed in North Carolina. They're very common in the South. They're not as common up north for political reasons. But again, the problem is that people who use school resource officers don't realize what they're supposed to be used for. They're not security. They're trained in a specialized federal program under the COPS grant to actually do policy, to do programs, to do some counseling. They're really a Swiss Army knife, and generally they're not used very well or deployed very well. Using a police officer locally, like a juvenile officer, or having an officer liaison, that actually is a good idea, and there is in the block grant that every police department gets, there is a certain amount of money for community policing. And so all you have to do is make sure that you talk to them about what they're using their community policing money for, and that allows them many times to be on campus and to assist in monitoring and intervention. But does Andy, you or Jack want to talk about that too?
The other issue that comes up all too often is the converse of that. The SRO officers that we oftentimes see have been well-trained, well-prepared to deal with a school environment. They've not only got the policing aspect, but they've gotten the educational aspects honed in very well. Where we see problems is school districts who make the assumption that they can go out and hire somebody off the street who is poorly prepared. In many instances, what we see in our audits is that those officers, in many respects, actually exacerbate the problems that the school has, because they may have the policing aspect in their training, but they do not have the school relationships and the school educational training aspects that allow them to function to the best of their ability in schools. The other thing that I want to mention is that what we also see, and it's usually because of money, is school districts will wind up hiring what they call hall monitors or study hall monitors. And again, many of the times what we're seeing in our audits is those folks have not been properly prepared for the kind of work they're being asked to do, and thereby exacerbate discipline problems within their schools.
Oh, let me add something, Andy. In New York State and in other states in New England and out in the Midwest, there is state law that says that any security person who works in a school has to be certified and trained. And so what they'll do is the school districts will give them a different name, like Andy's talking about, call them hall monitors, to prevent them from spending the money to go out there and get the state required training. Well, holy cow, that's a liability issue. And so, again, we see that being done. Also, I want to bring up something else, and I'll gladly send it to Matt later on, and he can send it to everybody. If you have a police officer on your school campus and you are a public school, you cannot ask them to be disarmed. It is against federal law, and it is also against every state law in the country. And we're federal law enforcement trainers, and I will tell you, we've dealt with this before with training SROs. There is state law in every state, and there's federal law that prevents you from telling them to be disarmed. And we hear school boards all the time say, well, we heard from our attorney that it's a liability issue, and the bottom line is it's not a liability issue. It's a liability issue for the officer who has no weapon when someone comes into the school. And by the way, the U.S. Code is Title 18, Part 1, Chapter 73, and that law specifically states that no civilian can disarm or require a law enforcement officer on a local, state, or federal level to be disarmed in a public place and including a school. So this is another liability issue that we want to talk about too. So
we have just one more from Sean, who asks, when students are providing their own transportation, what policies should be in place to manage the students, make sure that they are leaving the campus?
Andy?
Well, the first policy is an issue of supervision. And where you see this problem more often than not is at a middle school level, and it's usually as a function of after-school events for middle school students occur 5, 6:30, and schools will dismiss from 2:30 to 3 o'clock. And what will happen is that there is absolutely no supervision for those students. They are wandering around, and schools and administrators feel that they are not responsible for them. Nothing could be further from the truth. While those students are there on your campus, you have a duty to supervise. You have a duty to make sure that your parking lots are being supervised for high school kids. Once they leave that school property, as if they're driving their own vehicle, they're off school property, I guess you can breathe a sigh of relief, but even then, I'm not quite sure that you're totally off the hook. And Jack, perhaps you can pick up on that.
Well, again, it's all fact specific, but I think you touched the bigger issues, which is the management of your school campus. I mean, that's what it's really all about.
Well, also in many of the states we work in, last year in 2008 and 2009, many states changed their language. This is New York, New Jersey, Wisconsin, believe Indiana also, changed their language to say door to door, that a school is responsible for the safety of students door to door, meaning the door of the school to the door of their home. And so any kind of campus, any kind of school that has open campus policies is really gambling. We think that's just unethical to allow seniors, for example, to go off campus for lunch breaks. And many times when we tell our clients, you need to stop this, they say, well, the parents will be up in arms. and they want it because they had it when they were in school. Again, you're the educators, you're the professionals. Stand up to the public and say, this is not safe. And law enforcement doesn't want it. They don't want these kids running around doing whatever at lunchtime, many things nefarious. And the bottom line is that the law, the state law, is being violated in many cases, and attorneys who are bringing suits against school districts need to understand that also.
Well, you're talking basically about the portal-to-portal provisions.
Correct.
And where most people usually define that, it deals with transportation and busing issues. And the definition that you're also including in this is the schools that have open campus during the day, the high schools in particular that have open campus, that's a different kettle of fish because you're clearly responsible for those kids, whether they drive to school or ride the bus. If you have, especially if they ride the bus, and you have an open campus and you're letting those kids wander into town or wherever, you're asking for a major problem under those circumstances.
That's right.
Okay, well, we're going to wrap things up. It's the top of the hour, and I want to thank Dale, Andy, and Jack for taking time out of their busy schedule to put this presentation together. It was a great presentation, very informative, and I thought the Q&A session was just amazing. It was great. If you'd like to speak to either Dale, Andy, or Jack about a specific matter or case, please feel free to contact us at 800-523-2319, or you can email me at mhyde@tasnet.com. That email is on the screen. We'll be sending out a link to everybody who registered and attended for this event, which will have the archive recording and the PowerPoint presentation included in the email. We'll also send out a link to past presentations that are contained in our Knowledge Center. Our next webinar for clients is going to be on Thursday, January 21st at 2 p.m. It's going to cover pedestrian accident reconstruction. If you didn't receive an invitation for that or you want to receive an invitation, please shoot me an email again at mhyde@tasnet.com. If you have any follow-up questions or comments for Dale, Andy, or Jack, please either use the chat function that's on the right-hand side while this event is live, and I'll keep that open for about 5 minutes, or send me an email at mhyde@tasnet.com, and I will do my best to forward it on to Dale and his team, and we'll get you a quick response. Thank you again for taking time out of your day to be with us. We hope that you attend future TASA events, and keep us in mind the next time that you need an expert for a case or a project. Thank you very much, and enjoy the rest of your day. Thank you to Dale, Andy, and Jack as well.
Thank you, Matt.
Yep.
Bye-bye.